Have you ever wondered where do international laws actually come from? Who decides what's legal or illegal between countries like war, human rights, or sea borders? Today on Knowledge Suitcase, we'll unpack the sources of international law, the foundation that hold the world's legal order together. Keep watching till end. International law governs how countries interact. It tells them what they can and cannot do. Now, unlike national law, there is no single global parliament or police force to make and enforce laws. So where do these rules come from? The answer lies in Article 381 of the Statute of the International Court of Justice (ICJ), which clearly lists the sources from which international law is derived. Let's go step by step through each one. First, international conventions or treaties. These are written agreements between states, like contracts between countries. They are binding only on those who sign and ratify them. The golden rule is pacta sunt servanda, meaning agreements must be kept. Examples: the United Nations Charter 1945, the foundation of the UN, the Geneva Conventions 1949, rules of war and protection of civilians, the Paris Agreement 2015, tackling climate change. Treaties are the most formal and explicit source of international law. Next, customary international law. This is law based on consistent state practice followed out of a sense of legal obligation known as opinio juris. In simple words, when countries act in a certain way for a long time because they believe it's legally required, it becomes customary law. Examples: immunity of diplomats, prohibition of genocide or slavery, freedom of navigation on the high seas. Customary law is powerful because it binds all states, even those who never signed a treaty. Third, we have general principles of law recognized by civilized nations. These are fundamental legal ideas that exist in almost all national systems used by courts to fill legal gaps. Examples: good faith, every agreement should be made honestly, equity and fairness, res judicata, a matter already judged cannot be reopened, narrator. Now let's talk about subsidiary sources. They don't create law, but they help interpret it. 1. Judicial decisions. Decisions by the International Court of Justice or even national courts can clarify what the law means. Example: the Nicaragua case 1986, where the ICJ defined the rules on the use of force. 2. Teachings of eminent jurist. Writings by scholars like Oppenheim, Brownlee, and Shaw are often used by judges as reference material. These are not binding, but they carry moral and intellectual authority. With globalization, new forms of law are emerging, what we call modern or soft law sources. These include UN General Assembly resolutions like the Universal Declaration of Human Rights 1948, decisions of international organizations, for instance, rulings by the World Trade Organization (WTO), codes of conduct, and declarations that shape norms even if they are not legally binding. Such instruments often evolve into customary law over time. Let's summarize the sources of international law. Treaties are binding like UN Charter. Customary law is binding like diplomatic immunity. General principles is binding like good faith. Judicial decisions are persuasive like ICJ rulings. Juristic writings like persuasive, Oppenheim. Soft law minus UN resolutions are non-binding like UDHR together. These sources form the legal backbone of international relations, guiding how nations behave in war, peace, trade, and diplomacy. So next time you hear about a country violating international law, remember those rules come from treaties, customs, and principles carefully built over centuries. If you enjoyed this video, hit like, subscribe, and share to keep learning with Knowledge Suitcase, where curiosity meets clarity.